What's up, everybody? It's Peter Tragos, the lawyer you know, and on this channel, we break down the trials and cases you care most about so you can understand how the American civil and criminal justice system works. And we try to make sure you understand what your rights are in every situation, which is why we try to walk you through the entire legal process while also answering your insightful questions along the way. And while it's not legal advice, it's always exciting. So buckle up for another episode of The Lawyer You Know. What's up, everybody? And welcome back in as we're providing a little update here on the Lori Vallow Daybell situation. A lot's been going on, a lot of motion practice, a lot of objections as we get closer to the trial date later this year. And today we're going to talk about the state's objection to Lori Vallow's motion to dismiss for lack of speedy trial, as well as some discussion on as to what mental health information or evidence or testing or testimony may or may not come in at trial and how the two sides see that differently. I believe the hearings are today, February 9th. So we're probably going to know more about this today as the hearings come out. So before we get into the mental health information, we're going to start with the state's objection to Vallow's motion to dismiss for lack of speedy trial, which we discussed on a prior episode. So I'm going to bring that up here. And as I do, hit that like button if you still are interested in this Vallow Daybell situation. I know that there will not be cameras in the courtroom, so it's a little less easy to follow because of our inability to watch what's actually happening in these hearings, and we're having to wait for reporting to hear what happens and getting it kind of secondhand, which is tough. So hit that like button and make sure you're subscribed to the page with that reminder bell. Sometimes YouTube unsubscribes you. So if you came for this case and you've been waiting on videos in this case, make sure you're subscribed. I just pulled out a little part from the state's objection. In analyzing the defendant's speedy trial rights, it's important to start from the correct date. We pointed this out as well. They started from some charges that went away and were end up dropped against Lori Vallow just to make it seem like the longest timeline possible. But the state says, which is the triggering event starting the clock. The defendant's motion to dismiss notes the defendant was arrested in Hawaii on February 20th of 2020. However, this arrest was conducted pursuant to a warrant in a prior case where substantially different offenses were charged. The relevant time calculations for prejudgment incarceration are determined by the nature of the offense. The defendant's assertion that the time spent incarcerated for substantially different prior charges should be used to calculate the defendant's speedy trial time is inaccurate since the calculation involves different case numbers and different offenses. They're 100% right here. The state's totally right. In this case, the defendant was arraigned on the indictment in front of the district court on April 19, 2022, although the indictment was returned by the grand jury on May 25th, 2021, because of the competency issues raised in a prior case and the defendant's subsequent hospitalization. The arraignment was delayed. This delay was not attributable to the state. Therefore, the triggering date for the speedy trial analysis is April 19, 2022, pursuant to the constitutional guidelines, as well as IC section 19-35013. So we already talked a lot about how we felt like because of the mental health issues and hospitalizations and competency issues and pauses of the case, this was the main reason why the speedy trial was not going, or why this case should not be dismissed because of a speedy trial violation. However, in other parts of the motion, the state mentions other extenuating circumstances and the fact that if this trial was technically going to be done within the speedy trial period, it would have to be tried on February 18th of 2023. So this is interesting. We're having the hearing on February 9th. So technically, instead of dismissing it, the state could say, fine, let's try this case tomorrow. Let's get this case tried before February 18th. And I don't know if they could try it that fast. It seems like they need months to try the case. But technically speaking, they're not SOL because the way they calculate it, February 18th would be the speedy trial deadline. But they are saying that this trial is only 44 days later. So with all these extenuating circumstances, including the competency issues and the pauses that are not attributable to the state, and the fact that Lori Vallow filed a motion demanding a change of venue, in this case, his venue changed by over 100 miles, 44 days is not presumptively prejudicial, is what the state argues. I kind of agree with the state, although I do think speedy trial is something that should not be messed with and should be held to a T and strictly construed. So I would be okay if the judge said, you got to get this done by February 18th or something, or having to find some delay attributable from the defendant, which competency issues are not attributable to anybody. They just pause the case and stay the case. So it is interesting. It's a legitimate argument for everybody that thought it was not a legitimate argument. This trial is going to happen over a month later than it should for it to be within the speedy trial. So if the judge dismisses the case, they would arguably be well within their discretion. I do not expect that to happen, but you can expect this to be an issue on appeal. Next, we're going to get to the mental health issues. It seems like I have not read the state's motion. I couldn't find it. I don't know if it's sealed because it's dealing with mental health issues, but it seems like the state wants to bring in their expert or testing that was done on Lori Vallow to say that she does not have mental health issues or did not at the time that these crimes were committed, as to not have sympathy or make the jury think that, she thought that they were ghosts or zombies or whatever, to not play a mental health angle because the defense is not bringing in their experts to say that she does, even though the defense experts, in fact, do say she suffers from mental health issues. But the defense, as we'll read in their response, want to wait until the penalty phase, if we get there, not the guilt phase. And because the defense isn't going to use it in the guilt phase, the state shouldn't use it in the guilt phase. So I couldn't find the state's original motion, but it seems like they want to use some mental health stuff to, I believe, prove that she was not and did not suffer from mental health issues. So here it is. Objection to the state's motion regarding mental health evidence. Comes now, the attorney for the defendant, and object to the state's motion regarding mental health evidence filed January 26, 2023. A lot of you send me this stuff, so if you find it, send it to me at Tragos Law on Twitter or Instagram. Make sure you give me a follow there as well. The defendant has determined that at the guilt phase portion of the upcoming trial, no expert witnesses will be called by the defense, which will support a claim under Idaho Code 18207. Idaho Code 18207 provides that mental illness is not a defense to a crime, but mental illness evidence can be presented if it negates an element of the crime. We talked about how this is basically their insanity defense. It's not guilty by reason of insanity like it is in some other states, like my home state of Florida. The defendant has never made any concession or admission that she is guilty of a crime, which, as we told you as well, in Florida, you have to say I was guilty. I did what they said I did, but I'm not guilty because of my insanity at the time. They're saying she has not made that concession, which a lot of affirmative defense is same thing as self-defense. Yes, I did shoot that person, but I did it in self-defense. So therefore, it cannot fit into the category of murder. So we know that those types of things happen and those concessions are made. They're saying she did not do that in this case. Therefore, if no crime was committed by her, there is nothing to negate. You get what's going on there? She's saying, I didn't have anything to do with killing my kids. So the zombies or the mental health issues or whatever, they shouldn't come in because I had nothing to do with killing them. Which then, I guess, since I haven't seen the state's argument, this could be something that points us to maybe the state does want to bring in that she was mentally ill and that she did think her kids were zombies and that's why she killed them. But she's not going to use the insanity defense, so they're going to use insanity to convict her, or mental health issues to convict her. Or that's why she killed them, because she thought they were zombies or were going to be zombies, or she was saving them from something. Who knows? Without the motion, I don't know exactly how the state was trying to use mental health issues, but it seems like they absolutely were, including trying to call their expert. The court and the state has received all of the written reports regarding defendant's mental illness, which are possessed by the defense. All of the reports would include the reports from Dr. Landers, the 4 doctors employed by or who contracted with the Idaho Department of Health and Welfare and are at State Hospital North, and the defense expert, Dr. Cunningham. All of these mental health experts agree that the defendant suffers from a mental illness in varying degrees, which is not unusual, that they're not exactly the same, but they all have a little bit of a different opinion onto what degree of mental health issues she suffers from. Therefore, the state cannot argue to the jury that the court could not, Therefore, the state could not argue to the jury and the court could not agree that she is free from mental illness, because that would contradict the evidence. So this is what points us in the fact that I feel like they're going to argue she doesn't have any of these issues, and therefore she just did it with malice aforethought. She wanted to get them out of the way so she could go live her new life with her husband, leading a cult or whatever they were going to do. Paragraph 4, the mental illness reports, they're saying you cannot do that because you know and you have evidence that she does in fact have mental illness. We're not going to bring it in, but you know that you'd be arguing something that's counter to what the evidence actually is. And they're right. The defense is right about this, I think. Number 4, the mental illness reports have been determined by the defense that they go more to mitigation than to guilt or innocence. The defendant believes that she will be acquitted of all charges and the penalty phase will not be necessary. because it's a death penalty case. So you get convicted in the guilt phase, then you go to the penalty phase. Is it going to be life or death? She thinks she's going to win here, so this won't come up. But if it does, however, if defendant is convicted by a jury, it would be an appropriate time to present the mental illness evidence to the jury in consideration of the potential penalty. So just like we saw a lot in the Nicholas Cruz case, then you can see a lot of mental health evidence come out during the penalty phase of a death penalty case after the defendant is convicted, if they are convicted. The defense experts, Dr. Cunningham and Dr. Watson, have been asked by the undersigned attorneys to provide a summary report for a potential sentencing hearing in this case. All mitigation evidence is relevant and admissible at sentencing. As soon as those summary reports are received, they will be shared with the government attorney. So they're still giving them to them from their experts. Once they receive it from their experts, they'll send it over to the state. Since the defense is not presenting a mental health defense, which would negate an element of the crime at the guilt phase portion of the trial, then likewise, the state will not be provided an opportunity to call their expert witness, Dr. Wellner, at the guilt phase portion of the trial. And I think that they are 100% correct, unless there is some other reason to call this expert witness or to get into mental health, besides to say she doesn't suffer from mental illness, or to say she was perfectly fine and clear mind when she made these horrible decisions of what she did or planned or conspired to do to her children. So I think they are right that if the defense doesn't bring in this evidence, then you can't rebut this evidence. It's like if the defense puts on no case at all, then they cannot have a rebuttal case. The state, if the defense waives their case in chief, the state cannot have a rebuttal case. They can't save things for that. And mental health cases or not guilty by reason of insanity cases, usually it's almost like two trials. What happened? And then the mental health experts. And then the defense will bring up their mental health experts. But how the state tries the case is, here's how we know the murders were committed. Then they have to wait for the defense to bring on their mental health experts. And then the state can respond and rebuttal with their mental health experts after the defense presents that affirmative defense. So they're saying, if we never present it, then you can't bring any evidence rebutting it. And I think they are right. But it seems like the state's saying, we're not rebutting anything. We're just bringing her in to say she was of sound mind or didn't suffer from mental illness. So we will see today, hopefully later today, how the judge rules on the motion dismissed for speedy trial, on this motion regarding mental health issues. And there are a couple other motions on the docket. So we're going to get some more answers at the hearing today, February 9th. And we will continue to update you on this case as we get closer and closer to that 2023 trial date, unless it goes away and gets dismissed. But if you want to continue following this case and want me to continue following this case, please let me know in the comments. Let me know what you think about this. If you have any questions or anything like that, make sure you subscribe and like the video on your way out. Thanks for joining me today, and I'll see some of you tonight at the live Q&A and recap of the Alec Murdaugh trial. I'm out of here.